I'm Corye Dunn. I'm the Director of Public Policy at Disability Rights North Carolina, our state's protection and advocacy agency. Thanks for joining us this evening. I think many of you know we held a similar session yesterday during sort of traditional work hours. So we have the benefit of having had this conversation once already in the last couple days, and we'll be using some of the information, the questions that we got for that session, as well as any you submitted in advance today to kick off, and we'll be going through what's going on with the case as of now. And then there will be some time for Q&A after that portion. If you're not familiar with Zoom webinar, if you want to submit a question for the panelists to answer, you'll want to click on Q&A, which is the little question mark box at the bottom of your screen. And that will allow you to ask a question, and then that'll give us the opportunity to group questions together that are on a similar topic, or otherwise kind of put them in an order that makes sense for your fellow attendees. So with that, don't hesitate to put any of your questions in the Q&A. If you have questions that occur to you after the fact, though, that is okay too. We will offer information on how to follow up, both on information on this webinar, and if you have questions about something that is not within the scope of what we're covering this evening, we'll tell you how to do that too. I want to say we have a little bit more intimate a group tonight than we had yesterday. So hopefully we'll have time to get to everyone's questions, but we will be sending a follow-up email to all attendees of both yesterday's and today's session. So, so you may get your questions answered there as well if it doesn't come through clear enough today. So I want to turn it over to my colleagues, Lisa Grafstein and Emma Kinyanjui, and I will see you in a little while.
Good evening. Thank you for joining us. My name is Emma Kinyanjui. I'm legal director here at Disability Rights North Carolina, and was one of the attorneys on the case. So I'll give you a bit of background and context for the case, and then Lisa will share some more information with you. In September 2013, Disability Rights North Carolina and the Council on Developmental Disabilities partnered to examine the reasons that people with intellectual disabilities were being institutionalized in adult care homes. We also wanted to identify the barriers that were preventing those that chose to leave institutions and transition into the community and a home with services. So we began a 3-year monitoring project across North Carolina, and during which time we talked with numerous adult care home residents, guardians, and family members. And what we found was that there was a funding imbalance in favor of providing care in institutions. And there was an inadequate plan of how to balance the distribution of care. So during this time, we also received numerous calls from people with disabilities, with intellectual and developmental disabilities, and from family members that were telling us they were at risk of being placed in an institution because services in the community were not approved or were not available. In May 2017, we filed a complaint, and in our initial complaint, we identified key problems. There was a lack of adequate community-based services that was leading to the over-reliance on institutions. There was an inadequate provider network. The Innovations Waiver list was growing and failing to keep pace with the needs in the community. And for those on the waiver, there was a downward pressure on service budgets. There were service reductions, there was unclear standards for determining medical necessity, and it placed individuals at risk of institutionalization. And we also pointed out that though there have been periodic attempts The state didn't have an Olmstead plan. We lacked an actionable blueprint or a plan for supporting individuals in the most integrated setting possible. So the state tried to have the case dismissed, but the judge let us proceed with our core claims in the case. And as part of this process, including discovery, we were able to learn a lot about the problems within the system and the barriers with regard to access to services. And this led to our challenging the supports intensity scale, the SIS as it's called. There were inconsistencies in the budget process and resource allocations, and our advocacy led to changes in the DHHS and the departments, or the Department of Health and Human Services guidance to MCOs about limiting services for those on the waiver. It also led to Joint Communication Bulletin 400, which provided further guidance to MCOs about their obligation to comply with Olmstead and to provide people with IDD access to home and community-based services and avoid institutionalization. There were contract amendments that were made with MCOs to improve and enforce compliance and improve data collection. So in February 2020, we obtained a legal ruling from the court that the state is violating the rights of people with IDD by unnecessarily institutionalizing them and placing them at risk by not providing home and community-based services that they needed. And this ruling was significant. It requires compliance with the law that services be provided in the most integrated setting appropriate, and it anchors an enforceable integration-driven remedies. With the liability established, it became time for a plan to remedy this imbalance in the system of care. The state requested a chance to come up with a plan to comply with the law, and the court agreed. So the state proposed an Olmstead plan. However, the judge determined that the plan that they offered was not adequate. It was a list of activities to take, but it lacked real measurable goals to address the unmet needs. So it was because the state had not come up with a viable plan, in November 2022, the court issued an order that included benchmarks and targets for the department and for the state to end discrimination. That order included the elimination of the waitlist. Then at that time, it was more than 16,000 people on the list. In order to end assistance to transition people to the community for those that wanted it, and greater access to direct support professionals. As for the waitlist, it's worth mentioning that we see the state as well as the department. So even if the department could not unilaterally create waiver slots, that doesn't mean that the state could not increase the number. We understand that more slots would require more care providers. And in that remedy order, if carried out, it would have also been a tool for ensuring adequate DSP pay and training. It was a comprehensive order.
So I'll pick up from there and appreciate you all being here, appreciate Emma's background on how we got to where we are. I'm going to talk next about, and I should say I'm Lisa Grafstein. I'm Litigation Counsel at Disability Rights North Carolina. And along with Emma, we have been litigating this case as well as with some private counsel. So picking up from where Emma left off, after the remedy order was issued in 2022, we got a lot of very positive feedback about what the order would provide in terms of the elimination of the wait list. People were really excited to see that, as well as the other aspects of the order that were going to be providing direct relief and benefits to folks. But we also heard from people who had concerns about one provision that would have limited the admissions to different types of facilities after 8 years. So the remedy order had pieces in place to go forward for about 8 years. And then at the end of that time, there was going to be a limitation on certain admissions. The main concern that people raised was around ICFs. So, it was a very intense time of conversation. And although we disagreed with some of the rhetoric that was being kind of discussed around that provision, we did think it was really important to move forward with the other provisions of the order that everybody agreed were very positive.
So we proposed to the state and to the department that we jointly agree to ask the judge to remove that one specific provision that was raising concerns for people. But however, the state declined to agree to do that with us. Instead, the state opted to appeal the decision that had eliminated the waiting list and had provided the other remedies, and also appealed the order from 2020, in which the court had said the state is violating people's rights. So because the appeal created uncertainty, it would be going from the current judge who's handling the case up to a court of appeals. That placed the case at risk, and the risk certainly was on our mind, but it was also clear that any appeal takes a number of years to resolve, so that everything would have been paused for several years. There are cases currently now at our state Supreme Court that started around the same time, if not before then. So it's really a multi-year process. And of course, there's always the risk of reversal on appeal, although we strongly believe in the strength and importance of the case. But had the appeal moved forward, it was unclear where we would be now, let alone in the future. So this led to some months of negotiation and conversations between Disability Rights North Carolina and the state and DHHS, which resulted in a consent order, and that's the consent order that's now in place. And we'll talk about the consent order itself in just a minute. But I do want to emphasize, we even today would have preferred that 2022 order as with the amendment that we had proposed, so that the waiting list would be on track to be eliminated and these other provisions would be in place. So our preference was the order that we argued for and that the judge awarded. However, because of the status of the case and the appeal, we thought it was important to come to some agreement with the state moving forward. One of the primary benefits from our perspective about the consent order is that it resulted in the dismissal of the appeal. So the state is no longer taking that appeal. And that means that the original order, which said that the state's violating the rights of people with IDD, that's a formal order and a final order now. It's not up for debate and it can't be appealed again. So the only question going forward, as Emma said, is how to fix the problems, right? That this is what we call the remedy phase. And that's where we are now. So the case in a remedy phase isn't over until the state can prove that it has fixed the problems going forward. So that's how we got to the consent order. I'm going to talk a little bit now about what the consent order does and why we chose these particular things to include in the consent order with the cooperation of the state and DHHS. So the consent order was entered in May of 2023, and it created a 2-year period of compliance with certain benchmarks and with some data collection. And there are some provisions that go beyond that 2 years, but most of the things that are happening within the consent order are occurring within this 2-year period. During this time, the state is providing and is required to provide quarterly reports regarding certain benchmarks, which again, I'll get to in a second, in the order, as well as those data reports. And each quarter, Disability Rights, DRNC, sends the state and the judge in the case our comments on that report. So these comments that we send, as well as additional information, are available on our website. And you can get to those. I think we'll be providing the link later. But we do also have quarterly meetings with the judge and with the lawyers for the state in order to go over where we are on the status of those benchmarks and the reports. So the benchmarks that are actually in the order, I'll go through briefly, and then in a minute, Emma's going to discuss kind of where we are on those benchmarks. The first benchmark in the consent order is similar to one of the benchmarks that was in the original 2022 order about helping people with IDD transition to the community. That original order had a specific number, which escapes me at the moment, number of hundreds of people who would be transitioned over the course of 8 years. And by transition, this is referring to people who would want to leave an institutional setting if they chose to, but were unable to do so and needed support to do so. So the consent order provides that 249 people with IDD would be moved from institutional settings to the home and community-based services of their choice. And that equates to about between 78 and 88 transitions per year through June 2027. And this is I think the one main provision that goes beyond that 2-year period that we're talking about. And again, all of this is if people, once they're informed about their choices, that they choose voluntarily to seek community-based services. We thought this was an important provision, and I think DHHS agreed with us about this, that there needed to be a more concerted and coordinated effort to identify people who wanted to be served in the community, but needed help with that transition, and sometimes needed help to understand what the options were. Okay, so that's one benchmark. The next benchmark really has to do with implementation for the Medicaid service that's called 1915I, which was just coming into existence at this time. The benchmarks for 1915I, and we can talk more about specifically what those services are, included transitioning people who are getting B3 services on the Innovations Waiver waiting list, transitioning those folks from the B3 services, which were ending, to 1915I, which is an entitlement service for folks with IDD. And also, that benchmark also includes timeframes for conducting assessments to get people connected with services. And in our session yesterday, one of the questions and one of the comments that came up was about struggles with those timeframes. And so that's something that's being tracked, and it sounds like something we need to have more conversation about how that process is going. So again, the appeal of the original 2022 order had eliminated the provision about, had that provision in it about eliminating the Innovations Waiver waitlist. And we did not have an agreement in the consent order, and don't have an agreement in the consent order about waiver slots. And what I want to emphasize about 1915I is it was just launching at that same time. And it's not a substitute for an Innovations Waiver slot, but the hope and expectation was at the time, and I think it remains a hope, that that 1915I will meet some of the needs of some of the people who are on the Innovations Waiver waitlist. So that's why we're tracking it in this context. Again, 1915I, having just been put in place, I do want to stop and say the reason why, as I understand it, that option was pursued is that there was a lot of advocacy in the IDD community around the unmet needs as represented by the people on the wait list, just tens of thousands of people who have been waiting for services. And the idea behind getting 1915I services is, even though it's a smaller array of services, perhaps there are people for whom that's all that's necessary, and perhaps there are people for whom that little bit of service would still help. And I don't mean to diminish it, not a little bit, but it's less than the waiver. That it might help folks who are while they're waiting, essentially, but not by any stretch a substitute for the waiver. Okay. So the next benchmark was around direct support professionals. And one of the things, obviously, we know is that people have had serious and significant struggles getting and retaining DSPs. And so we wanted to use that as a measure about making progress toward people having access to DSPs. So one of the things that one of the measures in the consent order is establishing what we're calling it's a technical term, but a minimum utilization rate for DSPs, which just means, are people getting all the services that they're approved for? If you're approved for 30 hours, but you're only getting 20 because you can't find workers, then we're trying to measure that difference. And that's what that measure is there for. And again, it doesn't necessarily, it's not a perfect measure, but we are trying to measure how many hours of, in this case, community living and supports are going unused because of lack of providers, as a way to sort of see, are things getting better or not? And then finally, the consent order had a plan, or had a process for implementing a plan for training and credentialing of DSPs. And the purpose of that is to help with the process of professionalizing that work and increasing pay. So those are the benchmarks. I'm going to turn it back to Emma now to talk about sort of where we are on the benchmarks that were set.
So overall, where we are is there have been some met, but we still have a ways to go. So the state has indicated that they have met benchmark 1A, which was completing 78 transitions. We would be able to verify that on the next quarterly report, and we'll track that progress through 2027. On benchmark 1B, around the implementation of 1915I, it's in progress. Those that were on B3 have been transitioned. 3,000 people have been assessed and completed the approval process as required. And there are an increasing number of people accessing at least some services. For now, care management seems to be the primary service. However, there are still thousands who may be eligible but have not been assessed. And data is lacking with regard to how long individuals are having to wait for those assessments. For people that are receiving 1959 services, the data is incomplete with regard to their continuing unmet need. As Lisa said, there are services that are being provided, maybe providing some help, but it's not all that they need to live safely with services. So 1959 service will benefit individuals that are currently waiting on the innovation slots or can by providing earlier access to certain supports. But as she said, it cannot replace the Innovations Waiver or eliminate the wait list. The services are limited in scope and type and service hours, while the Innovations Waiver will provide a much more comprehensive package for those with greater needs. So to qualify for Innovations Waiver, the person must meet the same institutional level of care as required for admission to an intermediate care facility. Note that an ICF level of care is not a higher level of care. It is the same standard that's applied in different settings. Bottom line, we believe that 1959 is helping, but we know that there's still a great deal of unmet need. Benchmark 2 is around the minimum utilization rates. So it appears that the 2024 benchmark was not met. However, 2025, which has an 85% utilization of community living and support services by the end of June 2025. We don't have final data, but the prior quarter's data suggests that the department will meet this benchmark overall. However, we're still not sure that each individual MCO will achieve. The data related to the level of services not used due to a lack of staffing is also still incomplete. DHHS has made a lot of progress in getting MCOs to report data, but there's still work to be done to ensure that we have a full picture of individuals' needs and barriers to receiving this necessary services. So Lisa's going to share what we've learned from that data.
Thanks. Right. So, as I mentioned earlier, we're doing quarterly comments on the quarterly reports that we're getting. And if you read those, and they're not that long, you can go read them. If you read those, you'll see that we've raised a lot of concerns about data collection, particularly early on in this process. There's been a lot of progress, as Emma just said, collecting information and putting that information online on certain dashboards that DHHS has put up. You may be familiar with Inclusion Connects, which was developed as a vehicle for reporting out the data from this case. So if you see reports that on Inclusion Connects, or you get information about Inclusion Connects, that is largely Samantha R data. That's being reported. That's where it's being reported, and the department is adding some additional information in that same portal on the website. But if you're looking for it on their website, that's where you can find it. So the data collection piece of this process, which we can talk about this in a little bit, but the data collection is not the purpose or the end goal, right? But the data collection is a part of the process. There are 21 data points in the consent order. And I'm not going to go through each one of them, I promise you. But the categories that are being collected mostly track the benchmarks we just talked about. The first one is transitions and diversions. So how many people are being diverted through additional services or are being transitioned. And we were just talking about those. It looks like those numbers are on track, and what we're learning in this process is that there's a certain amount of coordination of information and gathering of information that hadn't really been happening prior to the department having to sort of, in the process of complying with the consent order, going out and making sure that data is being reported in by the MCOs. 1915I implementation, as Emma was just saying, it's been progressing. Every report has shown more and more people accessing 1915I services. We are seeing that the predominant item is care management, and care management in and of itself isn't a service. It's sort of a portal into the services. It's somebody to help you navigate the services, and so. Although there's been an increasing number of people declared eligible and accessing, we are raising concerns around the fact that care management seems to be the predominant thing people are getting, because it doesn't necessarily get us further in terms of people accessing services. It's just a mechanism, really. So it's not a service in and of itself in the traditional sense. The continuing unmet need issue, which is a big one that we're trying to measure here, is as 1915I is getting implemented, how many people still have no services, or even if they're getting 1915I, they still need more. And this is I think the largest continuing gap in the information. We don't know the answer to that. So you have some folks who may be getting some services, but we're not able to collect data as of yet about, how many people need more than they're getting through 1915I and how much more. And the department has some measures that they're trying to use to kind of figure that out, but we're not there yet. And then the final area that's being tracked is DSP availability. Which, as Emma mentioned, the benchmark for 2025, we appear to be on track to meet that, but it doesn't necessarily, so that is good, but we're continuing to work on trying to figure out, based on the department's collection of data, when that other 15% of time that people aren't using, trying to make sure we understand, is it because they don't have a provider? Is it because some other reason? Is it because we just don't know? And again, the department is working to piece those pieces of information together. And I see Ginger Yarborough is on the call, and I don't think anybody's worked harder on this than she has. But we don't really have the exact information that we need, but the department is continuing to work on that, and we're continuing to advocate for getting that information in a way that makes it just really transparent and clear exactly what's going on, which I think we're still, like I said, is a work in progress. Okay. So a key takeaway really has been that a lot of important information that wasn't being collected before the consent order is being collected now, and that it's improving, and there's a ways to go still. One piece of that is that the department is putting a lot more data reporting in MCO contracts, which has really been a key means of getting that information. Again, I would identify the unmet need as the biggest gap, identifying how many people on the Innovations Waiver waitlist still have, how much need there is. What we do know very clearly is that we still have almost 19,000 people on the waiting list, and that's not acceptable. So that part of it's pretty clear. Again, data collection sounds technical and like it's not actually about getting more and better supports and services to people. And also 2 years feels like a long time. But the data itself is not the end. And so I just really want to reemphasize that. It's part of this longer term process of getting the state into compliance with the rights of people with IDD. And that means providing access to services in the community to those who want it, most prominently eliminating the waiting list. And the data is important as we work toward what happens next, but please know that our end goal is to make sure that this case does not end before we get everybody access to the services that they need in the place that they want them. And so I'm going to turn it back over to Corye now to kind of talk about what's next.
So now what? DRNC continues, excuse me, to address the issues our clients are facing through both this litigation and other measures. In particular, we're really excited to begin a project where over the next year, we'll work with partners in the IDD and legal services worlds to develop educational materials and direct services for family-facing transitions of caregiving. These are families where a primary caregiver is either aging out of their ability to continue in that role or seeking to make plans for that eventuality. And this project will help to make legal services and thoughtful guidance available to families facing these transitions. So stay tuned for more information on that. We'll be releasing more on that project in October. The consent order is specifically intended to be a temporary order, though, with additional orders to follow based on the data gathered. The idea is you need the data to decide what the next orders should be. At the end of the 2 years, which is next summer, DRNC and the state are to review the data gathered and discuss what should happen next. If we agree, we can propose that to the court, just like we did with the consent order. Or we may have different recommendations to the court. There will be several more quarterly reports between now and then, and we'll continue to provide our comments on those and make sure that they're posted for you to see. I believe that Kara has just shared to the chat some useful information, including the links to where we post those comments to the quarterly reports. Our position is that a lot more needs to happen before the issues we raised in this case are resolved. The two biggest are the waiting list and DSPs. We're going to continue to argue for eliminating the wait list and for adequate pay and training for DSPs because those two go hand in hand. The state's attorneys may ask the judge to dismiss the case next year at the end of the consent order period. If they do, we will almost certainly oppose that. Our hope is that we can all agree that so much more needs to be done about community-based services, especially the waitlist and DSP pay. The case has resulted in the development of trackable data, and DHHS has made a lot of progress collecting data and putting it online. Some of you on the call have been intimately involved in that, and thank you. And some of you have been with us as we've tried to figure out what the right pieces of data might be. And thank you for that as well. But tracking data itself isn't enough. It's essential. We have to do it. It's necessary, but it's not sufficient. Data alone doesn't change the lived reality of people with IDD and their families in North Carolina. We have to use the data to see if there's progress and to have accountability when there isn't, and to help us figure out where to put our resources. So to reiterate, we'll review the remaining quarterly reports. When the consent order ends next July, we'll be prepared to advocate for an additional order where we eliminate the wait list and get past the DSP crisis. Everyone deserves the right to live in the community of their choice, and we'll continue to work to make that happen. I invite you all to submit questions through the Q&A, and our colleague Cass is going to help us navigate any of those.
Hi, everybody. We have one question right now. And the question from an anonymous attendee is, the benchmark that we are meeting utilization and DSP availability, do we know if that includes relatives having to provide support? So it appears that the benchmark is being met when in reality it is not.
Right, thank you. And I think this question came up yesterday too. So what's being measured is how many hours of services, for example, or units of service have been authorized versus how many have been billed. And the gap is where we're looking at assessing whether that's because of a lack of a provider. Now, if a relative is providing paid services, that's going to count as billed, and so that's not going to be accounted for in this. And this was a really good point that was raised yesterday, and I'm glad somebody's raising it today as well. It's something that the data is not showing us yet. And I think it's got something we're going to have to dig into a little bit deeper and figure out how we're going to, I'm sorry, Jender's going to be sorry to hear this, but figure out how we're going to figure out which piece, where that fits in here. Because I think that is important that, natural supports are important in a lot of people's lives, but we also want to make sure that when family and friends are providing support, even if it's paid support, that it's something that that they're choosing to do. And we know from experience, and you all know from experience, that a lot of people do it because they have no other choice, and that it shouldn't be that way. And that's one of the things where we want to make sure that we are keeping in mind long term. So it's been a really good flag for us to hear that feedback or to hear that question and make us think about that a little bit more critically.
We don't have any other questions in the chat, in the Q&A right now.
Should be, there were a couple from email. Should we go ahead and do those now while people think about their questions and Ginger considers her life choices? I'm just kidding.
We kid because we love. We appreciate you.
Yes. I think I've got those up here, Cass, if you want me to look at them, or do you have them? You're muted.
Of course I am. The questions that people emailed,
Yes.
I am terribly sorry. I do not have those. I can go and find them.
I've got them up if that's okay with everybody.
Okay. Okay.
Yeah, and there were just a couple. We got some questions through the email that were not related to the case, and we'll deal with those separately. But the two, the first one that someone asked, it was sort of a series of questions that kind of boils down to: are we tracking where people are coming from in terms of those transition numbers, whether it's coming from out of state, or I'm sorry, out of state developmental centers, whether it's out of ICFs or AFLs, that sort of thing, although an AFL is not an institution in most cases, and whether they were moved into a single living arrangement, a family home, and what the if we're tracking kind of what happens with them afterward. And the answer to it is generally we're not. The department may have that information. That's not part of the reporting, and therefore we don't have that information about specifically where people came from. But the data collection, the who counts for as a transition or what counts as a transition, presumes that somebody's able to remain supported in the community for at least a year. And it's my understanding, and I believe from our conversations with the department, that they're also working with the MCOs to make sure that people are continuing to be tracked when they've been transitioned, as opposed to when they're just still in, if they're in, for example, an ICF, that obviously the MCO is tracking that, but apparently that it's a different process, or hasn't been the same process for people in the community. So that's a long way of saying we're gathering numbers at sort of a higher level, and not really at that level of detail, but I imagine that the department has information. And the other part of this question that was submitted was, where have the Samantha R plaintiffs ended up, and have those arrangements remained stable? And, without getting sort of into people's individual stories too much beyond what's been publicized and they've been given consent for, Samantha is still in the group home that she was able to be supported in, and is by all accounts doing well there. And her parents, I think, remain very pleased with that situation, as far as I understand it. The other plaintiffs, the case has been pending 8 years, so they each have kind of come to a place. A couple of them are in group homes, innovation group homes. Two of the plaintiffs had received waiver slots during the course of the case, and then we have a couple folks who'd been receiving supports in the home, but were at risk of those supports being reduced, and their family caregivers unable to continue to care for them. We've had to kind of help out here and there to make sure that they are continuing to be able to access those services, but people have, by and large, been in the same situation for a number of years now. So a fair amount of stability in the plaintiff group. But I appreciate people asking after them, because it's important. And I can do the other online question if you'd like, Cass, or it looks like we have-
I have it here. I am not sure I can, this is from Donna. I'm not sure I can articulate this correctly. Is there any data about family as provider numbers that increased during the pandemic that may have decreased post-pandemic prior to the implementation of 1915I? I think Donna did a good job.
I'm not aware of, well, we don't have the data as far as I'm aware. I don't know if it's been tracked that way by the department. I do think this issue of family as provider numbers is an interesting one that we're going to have to follow up on in a broader sense. So I don't know. I don't think we have the information on that. Unless Emma has any other ideas on it.
I do not.
And this,
I want to suggest that's part of why these conversations are so important, because as we dig into the data, we are sort of learning what is imperfect about it. So it's really valuable to have you all suggest ways that the data could be more useful and more informative. And that doesn't mean that we will necessarily know all the ways that the data is available to be sliced based on the data systems we have. but it's still helpful to know what would be most helpful to know so that we can advocate for that if it is knowable. So thanks for that.
Yeah. Another question from an anonymous attendee is, was asked last night or yesterday, will potential Medicaid cuts impact your continued efforts, especially as it relates to DSP pay?
It won't impact our efforts in the sense that our end goal is the same and the law and reality are the same, right? That there's an obligation on the part of the state. And again, I will make the distinction, DHHS has a budget that's given to them, but the state as a whole has an obligation to people with disabilities to provide services in an integrated setting if that's what people choose. So that's the lawyer answer. The math answer is, Medicaid cuts are going to hurt a lot of people. And that's not a good thing. I don't think we really know. I know that there's at the state level discussion of cuts to go into place October 1. I think there's efforts to try to stop that from happening. That will affect providers. I think so, and it will certainly affect providers in the IDD space. So it doesn't change our advocacy in the context of this case, but it's certainly something that the policy team is spending a lot of time thinking about. So maybe I should have just shut up and let Corey respond to that.
The answer is yes. Anytime you make massive cuts in Medicaid, it will hurt people with IDD. I've gotten a lot of questions in the last 2 months about news that people are hearing both from federal decisions and state level decisions that I think I could summarize literally dozens of them as basically, yeah, there are going to be cuts, but you don't mean my child, my mom, my loved one, right? And we do. We mean your child, your loved one, your mom. Everyone who relies on Medicaid is threatened by massive Medicaid cuts, and our entire healthcare delivery system is threatened by those cuts. So even if you are not a Medicaid enrollee, if you would like to deliver a baby in a rural county, you need a hospital. Or if you want to deliver in a hospital, you need a hospital. So having to drive 3 hours would make that more difficult, right? So it's not about whether there have been surgical cuts that are targeting this specific population. It's that you cannot make massive cuts in Medicaid at the national level without hurting people with disabilities. No way.
All right. For the next question, Jan writes, so just not abiding by the judgments, keeping being put off, or orders not being obeyed. I didn't think you can ignore court orders.
Same. No, not to be flip about it. No, I mean, it's a big frustration, and it's been a frustration. As we mentioned kind of at the top, as Emma went over, the original court order saying that the state was in violation of people's rights was February of 2020. And so I think the work has to keep continuing, and I don't cast aspersions on anybody at the department or anybody else about it. I think the issue is we have to continue to advocate, and as it stands right now, I should be really clear, no one's in violation of an order. These benchmarks, some of them haven't been met, and that's true. But we're pursuing that, we will have the follow-up order that, in our view, ought to be more directive about what needs to happen next. So I don't think we're there yet where there's a violation of any orders. But I appreciate and understand the frustration that there's a violation of people's rights that's continued to go on. And I think we've been really clear in this case that the state as a whole, again, not picking on the department or anybody at the department, but the state as a whole has not lived up to its obligation to people with IDD and people with a lot of other disabilities too, but in this particular case, people with IDD. And so all we can do is continue to pursue it and try to continue to get those court orders and try to continue to enforce. And I appreciate that. It's been a very long process. And for a lot of folks, it didn't start with this case. It's been going on their whole lives. So we do hear that and understand that. And and work with as much of a sense of urgency as we can. But this is the process that we're in right now.
This is just from an anonymous attendee, just a comment. Thank you all so much for hosting this town hall, your ongoing communication with the community about implementation updates, and highlighting the next steps ahead, particularly in anticipation of Medicaid cuts. I appreciate the offering of an evening event to accommodate scheduling.
You're
Appreciate the
welcome.
Yes. And if I can also add to all that, the lot of the frustration that people feel is turning into advocacy by some people. And I don't know, Corey, if you want to talk about that, council, North Carolina Council on Developmental Disabilities has organized around these issues. A lot of other people are organizing. So we press forward with the case. The lawyers are going to litigate the case, but there's absolutely room for people to be continuing to engage in advocacy, which again, I know people shouldn't have to spend their time doing, but we've all had to for a long time, and it looks like we're going to have to continue to do that for a long time.
So, yes, do not assume that we have no illusions, right? That litigation is not the only tool we need to use in this process. We certainly are engaging in policy advocacy with the legislature, with DHHS. We are absolutely encouraging people with disabilities and family members to continue to advocate from everything from how many total dollars come from the federal government and what are the rules of administering Medicaid in North Carolina, all the way from that to, what's the service definition for a particular service and what barriers exist to people accessing the service. Those are things we will continue to need to do. And your experiences are essential in that. We can't know exactly what needs to change unless people with disabilities and their families tell us. So we're not psychic. We are just determined, and we will keep asking, and we will keep listening to you, and we will keep trying to formulate those needed changes into both policy advocacy and use them to inform this litigation as it proceeds. And with that, I think we are through our questions. I really appreciate folks taking the time to join us this evening, and hope that we're going to see you at other events, both disability rights specific, but also at the DD Council and at the General Assembly, and at events convened by the Department of Health and Human Services. It's absolutely essential that people who are making decisions about your life continue to hear from you. And we recognize how much it matters to you, but also how much none of us can do this work without people with disabilities and families sharing your stories, which is way harder than sharing someone else's story. So thank you for that, for your persistence, for caring 8 years in about this piece of litigation. We're not going anywhere.